Hi, we're here at Davis and Crump, and I'm here with Mark Davis. And Mark, how long have you been with Davis and Crump?
I've been practicing law for 30 years, and the last 26 of those has been here with Davis and Crump or one of its predecessor law firms.
What types of cases do you handle here at Davis and Crump?
Well, I consider us a plaintiff personal injury law firm. What that means is everybody that we represent is either injured or disabled and is making a claim against somebody for money. The types of cases can be what I would call general boilerplate type personal injury cases like car wrecks, on-the-job injuries or workers' comp, premises liability like a slip and fall case. It could be maritime, it could be medical malpractice, nursing home neglect. We have those types of cases, and then principal focus of our practice has been defective drugs and medical device cases. That would be a case where someone is either injured or disabled or has some disease or condition caused by either a drug that is defective or unreasonably dangerous or some type of medical device.
Tell us about one of your more interesting cases.
Well, in 30 years, I've had a lot of clients and a lot of cases, a lot of which are interesting. One that sort of stands out, one of the more significant litigations that we were involved in some years ago in the late 90s, early 2000s, was the diet drug litigation. Some people may know of it as FinFin. We had quite a few clients that we represented around the country in that litigation, and our firm was actually had the third case that came up for trial in that litigation, and it was a multi-plaintiff trial, which is a little bit unusual where a judge allows you to have more than one plaintiff being tried at the same time, so that made it certainly very interesting there. You literally had to, I think we had 6 plaintiffs, and so we had to prepare all 6 cases at the same time, which was a lot of work. But probably one of them stands out more than any other, and it was a lady who lives a few hours from where our office is, and she had open heart surgery to correct a valve leaking problem, and the hospital had given her a heart-shaped pillow. I think initially just to protect, because when you've had open heart surgery, you want to protect that incision. And it was just something that she got in the habit of holding. And every time we would meet with her, whether it was preparing her for her deposition, at her deposition, she always had this pillow with us. And she also ended up having it at trial. I never will forget her in particular, and the good thing is we got a good result for her at the trial.
Who are some of the companies that you have pursued cases against?
Well, since I've been practicing law, I would probably say as far as large companies, which ones have we not had a case against over the years? We probably have had cases over the years against every major oil company, every major drug company, medical device manufacturers. I mean, it's just a whole car manufacturers. I've had cases that have gone to trial against drug companies, Wyeth Labs being one of them. We've had cases against Pfizer, the largest drug company in the world, Exxon, the largest oil company in the world. Probably the only company really notable that we haven't had a case, I've never had one against Microsoft, but maybe one day that'll happen.
All of your clients have serious injuries or medical conditions. How do you handle dealing with sick clients?
Well, it's difficult at times. Clients are going through not just medical problems that they've never experienced before, but those lead to financial problems which they haven't experienced before to the degree that they're having, and it's difficult for them. What we just try to do is just try to expedite the cases as best we can. We try to counsel the clients. Part of what we do as an attorney is handle their legal case, but a lot of our time is also spent counseling the client for other problems that they may have in their life.
If you had to make one recommendation to a potential client, what would it be?
Well, the obvious recommendation would be to let us handle their case. With our firm, it's no obligation to talk to us, to let us do an evaluation of your case. If you do decide to hire us, we work on a contingency fee. What that simply means is they don't have to pay any upfront money or pay any money at all unless we get a recovery, and then we would have just a percentage of the recovery. That's called a contingency fee. So there's no obligation to talk to us. There's no obligation to have your case evaluated. And then if they hire us, we do everything on a contingency fee basis.
How long does it take to conclude the typical defective drug or medical device case?
Well, that can vary anywhere from 1 to 2 years to 4 to 5 years, or anywhere literally in between. Probably the most frequent question that I get once we've already been retained in a drug or a medical device case is, when is my case going to settle? When is my case going to come up to trial? Everybody wants to know when their case is going to be concluded. Largely, that's some things are beyond our control. Yeah, sure, we can file a case, but in a typical drug or medical device case, the cases there are other cases, and they're all in front of one judge or several judges, and you can't just always control whose case is going to come up first. So that has a big impact on when someone's case can be concluded. We certainly try to move cases forward as quickly as we can. We try to get people's cases set for trial, settled as quickly as we can, because we know people are sometimes largely dependent on what they're going to get out of the case. They've lost wages, they've had incurred medical bills, and the only way they're going to get reimbursed for those is if their case is resolved.
Thank you so much, Mark. It was a pleasure talking with you today.
Thank you.